Welcome everybody. It's just gone 1 o'clock now, so we're going to start bang on time. As I think today we'll have a lot to talk about as well. So I wanted to take this opportunity to welcome everybody to our second webinar in the series that we're doing in conjunction with Legal Aid Board. I'm joined again by Stephen Cahill, who is the Managing Solicitor at the Chancery Law Centre, and he's representing the Legal Aid Board today. My name is Niamh McCarthy. I work for the Parental Advocacy Service, which is delivered by Barnardos, so supporting parents who are going through childcare proceedings. The focus of these webinar series are looking at supporting parents with access to good, accurate information and what it's like going through these processes as well. As we both know that there's a lot of different systems at play and there's a lot of complicated language. So today in conversation, we're going to explore the role of the solicitor and what that looks like in particular childcare proceedings. And just before I start grilling Stephen more like it, and he's going to bring us through that process. But before we start, I just wanted to let everybody know that we are recording these webinars and they will be available on the Legal Aid Board website and the Barnardos Parental Advocacy Service website as well. We will have links in the chat and also on a slide at the end for people to access those recordings. From the first webinar series, we looked at making the application for legal aid, and that recording will be going up on both websites near the end of this week as well. But if anybody has any questions about how to access those, please pop it in the chat and we'll direct you accordingly as well. We just want to also know that this is a very short space to discuss very complicated topics. So if there's any further questions you'd like to ask in the upcoming webinars, please pop it in the feedback form as well, or else get in touch with any of your local law centres or Barnardos Parental Advocacy Service with any follow-up questions, and we'll put all our details in the chat as well. So now that I've said all that, and you're probably sick of hearing my voice, I'm going to move on to some questions today to Stephen. And I suppose these questions have come directly from parents that we're working with and things that come up on a frequent basis. So last week, Stephen, you brought us through putting in the application for legal aid and what's that like. So as a parent who's done that, they now are about to be appointed a solicitor, but they may not really understand what a solicitor is and what's your role in a childcare case. So could you explain that a little bit for us?
Yeah, of course. So at its most basic, I suppose, a solicitor is a type of lawyer who provides legal services. In the context of the Legal Aid Board, and then more particularly childcare matters, the solicitor is the person who will be providing you, the parent or the client, with advices and or representation then in court if the matter should proceed that way.
And once I've put in that application to the legal aid, my local law centre, or I've had an advocate help me do that, do I get to choose the solicitor? Do I have to find a solicitor, or is one appointed automatically for me?
So once your legal aid application is received at a law centre, particularly if it's relating to a childcare matter, it'll be treated as a priority. You then will be offered and assigned a solicitor, essentially the first available solicitor, the one who's most readily available to meet with you and to take on your case as a matter of urgency.
Great. So even if I had court tomorrow and I had been I was very overwhelmed and I wasn't really able to get my legal aid application form in, but I eventually got it in, do you think I'd have a solicitor by my court date?
Yeah, absolutely. So particularly here in Chancery Street Law Centre, which is a more specialised unit that is designed to be quite reactive, and that's reflecting often the very fast-paced emergency nature of childcare proceedings. So if a parent applies to Chancery Street Law Centre, not just for urgent representation, but even just for advices in respect of general issues relating to their children, we would endeavour to meet with that person then and there. But if there was an emergency application to court, you would absolutely be assigned a solicitor immediately who would take on your case. That's a little bit more difficult now for some of the other law centres who aren't co-located with the courthouses, for example, but they would still treat your application as a priority and would certainly use best endeavours to assign you a solicitor if possible in that short time frame.
Yeah, because that was what I was going to say. Is it the same process throughout the country? So if I live in Thurles, is it the same as living in Dublin, or are solicitors appointed in different ways?
It's a uniform process, but the outcome is somewhat unequal given differences in resources and availability. So it is more difficult for a law centre who might have resources dispersed among a few different courts to react to an immediate and urgent childcare application. Whereas in Dublin, we're lucky in that we do have the specialised unit who are available to respond immediately. But any of the law centres across the 34 law centres across the country will deal with your application as a priority and will endeavour to provide a solicitor as quickly as possible.
Right, thanks, Stephen. And as a parent in this situation, why do I need a solicitor? Why is it important to have one?
So I think any legal matters relating to your children and their care arrangements are of the utmost importance. The Child and Family Agency can seek court orders that are of enormous importance and of huge consequence. So, for example, the most extreme order, I suppose, is what's called a full care order, which has the effect, if granted, of placing a child in the care of the Child and Family Agency, potentially right up to the age of their majority, so up until their 18th birthday. So it's incredibly important that any parent would seek legal advices at the earliest possible opportunity. So even you can apply for legal advices before you're facing the prospect of court, and that in and of itself might help you ultimately avoid a court case.
Thanks, Stephen. And in terms of, so you mentioned care orders there, and so as a parent whose child is gone into the care of the Child and Family Agency, they're placed under an interim care order maybe, and I'm just wondering, Tusla or the Child and Family Agency will present their case to their solicitor and they will have evidence to meet that threshold for the care order to be granted. As the parent, will I get to see all that evidence before court, or is that something my solicitor gets and goes through with me before court, or how does that all work?
Yeah, so again, I suppose that really kind of underscores the importance of an early application for legal advices. You've noted there that the Child and Family Agency, if they're bringing a case to court, will base that application, will base their case on evidence that they are hoping to adduce or to bring to court, or through witnesses that they're going to bring to court. So the role of the solicitor in childcare proceedings is to ascertain all of that information, to get all of the background information and reports from the solicitor from Child and Family Agency. So they then have an opportunity to go through it with the parent, with the client, so that you can take the client's instructions on it.
And there you were just saying about taking the client or the parent's instructions. What does that mean if I'm a parent in this situation?
So as a solicitor, part of my role is to analyse the case that you're facing. So I can outline the strengths and weaknesses. And then based on that case, I would set out my general advices to you. So whatever course of action I might be suggesting or advising. But that is just that. It's just my advices. You, the parent, the client, are not bound to accept my advices or to act on them. The solicitor acts on your instructions. So ultimately, you tell your solicitor what you want to do and what case you want to be presented in court and the solicitor acts on your instructions.
Okay, so in a real life example might be if the Child and Family Agency had applied for an interim care order and their solicitor had maybe approached yourself representing me and asked if I was in a position to consent to that order being granted, while there was an ongoing investigation or a report was waited to be completed. You may advise me to consent and I may not want to consent. Is that the kind of examples we're thinking of?
Yeah, that's precisely it. That's, I suppose, a relatively extreme example, but one that does arise quite frequently. It may be that on its face, the Child and Family Agency's case would be overwhelming, that you wouldn't be in a position to successfully oppose it in court if you were to contest it. And therefore, the advice might be different. The advice might be to, in that context, ultimately consent to an order, but it might be on very limited grounds, just to kind of help you a little bit down the road. But that still involves a parent agreeing to an order, and they're obviously perfectly entitled to not agree to that. Many parents wouldn't agree to that, and they're perfectly entitled to instruct their solicitor to oppose the application. And your solicitor will do that then to the best of their ability.
Great. And can other people instruct you, Stephen? Like if I'm say the father of my child, could he instruct you as my solicitor, or another family member that I may have that's supporting me, or a worker, for example, that I'm working with from a specialised service?
So any person with, I suppose, a legitimate interest in a child's care arrangements is entitled to apply for legal aid and advices around that. Childcare proceedings are covered by what's called the in-camera rule, so they're heard in private, and they're strictly private and confidential. So the only persons directly involved ordinarily in childcare cases are the parents, usually as respondents, and the social workers. But that's not always the case. So, for example, if you are a grandmother or grandfather who's looking after your grandchild for whatever reason, and the Child and Family Agency bring a case to court, it may just be the parents who are named on the court case, but you have a very legitimate interest, and you might have good grounds to be involved in that case, to be joined as a party, or to be heard. So there's a whole suite of people who are entitled and perhaps should be applying for legal advices when it comes to childcare matters.
Interesting. And when my case is in court, or it's due to be in court, there's a question in the chat which is kind of in line with this as well. But how do I keep in contact with my solicitor, and how do I get to meet my solicitor before court, or am I going to meet my solicitor on the day of court?
So I suppose it depends on the context in which you're applying for legal advice or legal aid. Obviously, if you're faced with, say, an emergency care order application, so you're in court that day, of course, just by its very nature, you're just meeting with your solicitor for the first time on that day. And the solicitor will do their best in limited time to explain the court process to you, the nature and consequence of the application, what's before the court, what orders might be made, and what does that mean. But then after court, your solicitor just doesn't, the solicitor's involvement doesn't end there. The solicitor would continue to advise you. They would write to you after court and meet with you after court to explain the outcome. Then also set it out in writing, would let you know the next court date, and would almost certainly look to meet with you in advance of the next court date, depending on the necessity and circumstances. But you, of course, can contact your solicitor at any stage and request a meeting or consultation, or you might have some additional information your solicitor should see. And of course, you should be sending that into your solicitor.
Great. And just about when I'm going to meet with my solicitor as the parent, and I know for a lot of parents in this situation, it's very overwhelming. It's very technical as well. The language is a bit difficult, even the in-camera rule, just getting your head around that. But is there something that would really benefit me as a parent in preparing to meet with my solicitor? Like, what should I best do to prepare?
I suppose there's no particular thing that you can do to prepare for court. Ideally, the first meeting you have with your solicitor would be an opportunity for, I suppose, just information gathering, and it's an opportunity for you as the parent to set out to your solicitor from your perspective, what is the background, what is the issue, and from there, your solicitor then will hopefully be able to explain to you what's before the court in a manner then that is more accessible, and try and avoid using too many legal terms and so on. I know lawyers are prone to slipping into that, but we do our best.
Yeah, we all are comfortable in the language we use the most, isn't it? And like going to a meeting like that for a parent as well can be very overwhelming. And I know a lot of our advocates will accompany the parent in those settings when the in-camera rule has been lifted for the advocate. But if there was a parent who didn't have an advocate, could their partner go with them, or a support person, or is that allowed, or is it not?
Yeah, you can certainly have a support person come with you, and they can be involved in consultations to a certain extent. To go back to that again, technical term, the in-camera rule, that is quite restrictive, and without the permission of the court, the solicitor, for example, wouldn't be able to go through the contents of many of the reports while that support person is there. So the support person might be invited into the beginning of a consultation, and those kind of rules and ground rules can be set out, and made very clear that it's always very welcome that someone does have a support with them to come to court. But ultimately, you need to speak to the parent by themselves for a while, because you take their instructions. And you also have to be careful then that you're not taking the instruction of the support person rather than the parent instead.
Yeah. And in those preparation meetings and preparing for court, would you as the solicitor ever speak to the social workers or psychologists or family support workers or whoever is involved in the case who may be given evidence, or do you always wait until it's in the hearing in the courtroom?
No, I suppose it's part of the preparation for a court is not just going through whatever reports are being brought to the court by the Child and Family Agency, but also looking for reports that the Child and Family Agency maybe haven't procured, and maybe you wonder why haven't they procured them. So, for example, if there is a family support worker who you as a parent have a good relationship with, and you think they might be able to say something positive for you, yeah, the solicitor would, with your permission, of course, write to that person and might seek reports. So yeah, it's certainly within our role to speak to whoever might be involved in the case with a view to assisting your case.
Yeah, that's great. Great to know as well, Stephen. And in some cases that I've supported parents on as well, there's been barristers involved. Like, what's the difference between a barrister and a solicitor, and why would a barrister be involved?
So a barrister is a different type of lawyer. They're one who specialise in court representation and making legal arguments and submissions to the court and conducting cross-examinations. A barrister cannot be instructed directly by a parent or by a client. It's only the solicitor who then instructs a barrister, and the barrister then would work with the solicitor on your case. So you would have the same solicitor who then might instruct a barrister. In the context, again, of the Legal Aid Board and childcare proceedings, in ordinary course, so usually it would just be your solicitor who would deal with your case, who would manage your file on a day-to-day basis, and also would be the one representing you in court. However, there are, or in some exceptional circumstances, the solicitor might make an application, what's called to amend your legal aid certificate. So the solicitor makes an application to the legal services in the head office of the legal aid board, in effect to ask for a permission to instruct a barrister. And that's really only done in exceptional circumstances. So that might be where there's an ongoing criminal investigation into the same subject matter. So it's very important to have the advice of counsel on that. Or if perhaps the most serious forms of abuse are being alleged, that it might be prudent to instruct a barrister at that point. One thing to note, if that permission is granted to instruct a barrister, it's open to the parents to request that a specific barrister would be instructed if they have a name of a particular counsel they would like. You can certainly ask your solicitor to try and instruct that counsel. If your solicitor makes that application and is seeking a permission to instruct a barrister, but that permission is refused by the legal aid board head office, that refusal can be either appealed or it can be reviewed as well. So if that situation arose, the process would be outlined to you and you could consider asking your solicitor to have that decision appealed or for it to be reviewed.
Okay, so let me just get it right that I understand it as well. So if my case is very serious and there may be a guardian investigation happening at the same time, that we would make an amendment to the legal aid application and see if it was possible for a barrister to be appointed. And if I had a recommendation of a good barrister or I had previous contact with a good barrister, I may be able to say, Stephen, could you approach this barrister as the parent? And that would be a possibility as well if they were willing to take on the case.
Yeah, that's precisely it. But it is really only in kind of exceptional circumstances, or if there's a particularly difficult point of law that's arising as well. So yeah, it does occur, but it's relatively unusual.
Okay, good to know. And so within the courts, there's different players, obviously, or different roles in terms of there's the Child and Family Agency, and I presume that they would be represented by a solicitor. A child may be a guardian ad litem may be appointed to the child's case, and do they have a solicitor in court as well?
So, because childcare proceedings are private, right, the only people who are in court are the judge, the social workers and their solicitor, the respective parents, their solicitors, and then if there is a guardian ad litem appointed, they would be present and they would, in 99% of cases, also have a lawyer instructed. So each lawyer is acting for a different party, so has a different role. So usually the solicitors for the Child and Family Agency are the ones who are the applicant, so they're bringing the case. Most commonly then the solicitors for the parents might be opposing the case. And then the guardian ad litem is a slightly more kind of nuanced position because they're not technically a party to the proceedings, but have been appointed by the judge to assist the court and to give the subject child or children's views and wishes to the court.
Right, and I think we're going to talk a little bit further about that in upcoming webinars. So again, if people have questions about that, please put them in the feedback form as well. The time just goes so fast this as well, but just I suppose kind of final questions are around if as a parent I'm unhappy with my solicitor, I don't feel it's going in the right direction and I'm just feel unheard. Can I change my solicitor or what happens in that situation?
So if you're unhappy with your solicitor or you just simply wish to change solicitor, you're perfectly entitled to make that request. It's certainly not automatic that request would be granted. If a parent makes that request, it's considered by the managing solicitor. So the managing solicitor will ultimately make the call as to whether or not it's reasonable to allow the person to change a solicitor. And that's one of the main tests. So is it a reasonable request that's being made? So then if the managing solicitor grants your request, then well and good. But if the managing solicitor ultimately decides against allocating a different solicitor, again, you're entitled to have that decision appealed or reviewed. And the managing solicitor would write out to you and let you know what that process is and how to engage in that. So it's always open to you to request a change of solicitor, but it's not readily granted, to be honest.
And the scenario the other way, is there ever a time the solicitor no longer wants to work with the parent?
So when somebody applies for legal aid, the person is granted legal aid in effect on certain terms and conditions. And the parent has to sign the legal aid certificate confirming that they accept these terms and conditions. And those terms and conditions will set out various expectations, but also certain things that wouldn't be tolerated. So if the parent was very perhaps abusive to the solicitor or to members of staff in the law centre, that there's provision for the legal aid solicitor to apply to have the legal aid certificate terminated. And again, that's a decision made by the legal services in the head office of the legal aid board, and any decision made could be appealed or reviewed. That's obviously a very last resort, and it's not something we would do very, very readily.
And my final question, Stephen, and then if you'd like to add any further comments, please feel free to do so, would be if I'm a parent where English isn't my first language, or I struggle with literacy, or I may have some other neurodiversity pieces happening, or my sight or deafness or that, will I be supported in my consultations with my solicitor?
Yeah, absolutely. So the legal aid board will make whatever accommodations that's within their gift to best assist you. So the first example you gave there was just someone whose first language isn't English. So the legal aid board would absolutely seek to have interpreters present during consultations, and also booked for court as well. So any accommodations that can be reasonably made, we certainly would do, yeah.
Great. Is there any final thoughts you want to add, Stephen? And I'm just going to have a little look at the chat to make sure I got all the questions that were in there. Some came directly through.
No, I don't think so. I think that was quite comprehensive, unless there's questions arising in the chat.
No, I think we've covered everything. It's more about, about the role of solicitor, barrister, how they're appointed, which we went all through. That's brilliant. And I think people were sending chats directly to me there, so they weren't seen directly in the chat. But also, that's so good, Stephen, for you to share your time with us today. We really appreciate it, because I suppose these topics are so complex as well, and it's such a difficult time for a parent going through this and to have to process all the information that's coming at them as well. It's great to have resources like this and just to be able to talk it through. And our next webinar, which we touched a little bit on today, is about that courtroom experience and thinking about what it's like, who's going to be in the courtroom, and just preparing parents for that aspect as well. So I think that's happening on Tuesday the 15th. Again, it's a lunchtime webinar. And I'm just going to share my screen with everybody just to put up the feedback form as well. And if you have any questions for that webinar or upcoming ones in November, which are around frequent questions parents may ask, and then on Tuesday the 17th of December, we're also looking at non-relative kingship care and family mediation. If any topics you want further information about, or you have further questions, please come to us at the Parental Advocacy Service or the Legal Aid Board. The QR codes are there, and in the Legal Aid Board website will bring you directly to your local law centre as well, so you'll be directed there as well. In the middle there, you'll see a QR code for feedback form, and I'm going to leave this up for a few minutes. I'm not going to sign off directly at half, so please give us your feedback. We really want these series to be a success, and we're open to any suggestions and open to questions for the future as well. So again, I'd really like to thank Stephen for his time today, and look forward to talking to you again on the 15th.
Yeah, thanks very much, Niamh. I'll see you then.